Media law is constantly evolving, especially with the creation of new websites such as YouTube, Twitter, and Instagram. The specifics of these laws are difficult to follow, especially pertaining to school.
Well, it's a precedent from the Supreme Court, and it hasn't been overthrown, hasn't been overruled at all. It's been modified. Probably more to your interest would be a subsequent course of Hazelwood versus Kuhlmeier.
Hazelwood versus Kuhlmeier was a Supreme Court case that took place in 1988, in which two controversial stories from a school newspaper were removed, one pertaining to pregnant teens and the other to children who had divorced parents. The court sided with Principal Robert Eugene Reynolds, stating that he had the final say over what could be published in the school newspaper. Journalists face legal issues. The most common are libel and defamation. Defamation is a false statement about a person, and that injures the person's reputation and/or income. When defamation is printed, it's called libel. When broadcast, it's called slander. Copyright does not cover ideas, concepts, and principles themselves, only the form in which they are expressed. By attending Sanford, we agree to the restraints that the head of school sets. Freedom of expression is granted through the Board of Trustees and the head of school. Any members of the administration have the right to censor material that is published. If this occurs before publication, it is called the right of prior restraint. The First Amendment helps to protect journalists in many ways. However, it hardly covers online media. It is important to protect yourself and others when publishing, and be mindful of the media laws in regards to your situation, whether you are writing for the Sanford News Network or the New York Times.